I'm Stephanie Baloris.
And I'm Laura Ketzel.
We're your hosts for Forrester's podcast, What It Means, where we explore the latest market dynamics impacting executives and their customers. Today, we're joined by Principal Analyst Enza Yiannopoulos to discuss the impact of the EU AI Act. Welcome, Enza.
Thank you. It's a pleasure to be here.
Let's start out with a level set. Can you tell us a bit about the EU AI Act itself and why it's such a big deal?
Well, the EU AI Act is the, first comprehensive binding legislation on AI systems, and that includes also what the Act itself called the general purpose AI system. So the generative AI would be a kind of subset in that category. Again, it's a big deal. There is expectation that this might, in fact, become the de facto international standard for regulating AI. A little bit like the GDPR was for privacy, there is an expectation this act might have a similar impact. And then, this act really is dealing with a little bit of a mission impossible. I mean, trying to create compliance structures around technology that changes on a daily basis and trying to govern the risks when the technology is used within use cases. But the way the business is going to use this technology also is very much unknown today. So it is a little bit of a mission impossible for that reason. And I think everybody is looking at the act because we want to see what happens next.
So Enza, you've said previously when talking about the AI Act that the best way to look at it is not as a kind of standalone momentous thing, but rather as part of a broader set of regulation and legislation in the EU that sort of aims to control consumer harm and promote consumer safety. Can you talk a little bit about the broader landscape that it fits into and kind of what you expect that to develop into over time?
Yes, absolutely. And I love to touch on this because I think it's something that most people might be forgetting. The AI Act is, in fact, just one part, is an important part of what the EU calls the AI regulatory framework. There is, in that framework, the product safety legislation. This is a set of 2 regulations that have been recently updated. They will be enforceable by the end of this year. And this is fundamentally giving AI the kind of primary role within the product safety legislation. So thinking about AI, thinking about software as product as such, it includes a number of new software security requirements that weren't there before. So very critical to look into that legislation. And this product safety legislation is very, very closely related with the AI Act in the fact that a lot of those domains within product safety legislation are going to be high-risk use cases in the AI Act. So very close relationship there. But there is also the new product and civil liability legislation as well. Those are directives. It means that every member state will have then to pass the directive at the local level. So we are going to see different version of that liability legislation, delays potentially. But the interesting part is the regulator is saying we cannot ask users to show the direct connection between harm that can be material or immaterial and the technology. So it's not for user to show that there is that direct connection. So what they are going to do is to ask individual to prove that they have suffered harm, and that harm is potentially related to the technology. And then will be on the provider of that technology to demonstrate that they are fully compliant with product safety if it's applied, with the AI Act if it's applied. And so compliance with this AI Act is not only a reason not to get a fine, but potentially is a reason to demonstrate that a company is not liable for harm that might be caused to users, consumers. So, it's those 3 pieces, the product safety, liability, AI Act, working very closely together. And then there is privacy, there is copyright legislation, there is consumer protection, and so forth that also need to be taken into account. All this legislation is potentially due an update in the future to more closely be together or come together with this AI legislation. So there is a lot going on in Europe on AI.
What is the status of the AI Act right now? I mean, it was passed, or formally adopted rather, but what's the next step?
We are almost there. I discovered recently that the different language version of the act will need to be formally now passed. So there is no changes in the text. The English version, we know it and has been again formally passed, but there are those other formalities that will need to be completed, and then the act will be published in the official journal of the European Union. We are expecting that to happen probably by the end of May. And 20 days after that, the act will come officially into force. And then we'll start with the countdown on enforcement. By the first 6 months, after the 20 days after the publication, the rules around the prohibited use cases will be enforceable. 12 months after, some of the rules around the high-risk use cases, those in Annex 3 specifically, will be enforced. And then other requirements will be enforced within the next 24 and 36 months. So it's not a piece of regulation that is going to be enforced all at once, but there is this kind of a timeline for the different requirements.
And when you talk about enforcement, how is the enforcement actually going to work with the AI Act? Will it work similarly to the GDPR or differently?
It's way more complicated the way the enforcement is going to work. Actually, in February, the European AI Office was officially launched. This is the new body within the European Commission that will deal with the requirements for the general purpose AI and a number of requirements for the prohibited use cases and high-risk use cases. I know that they have been hiring throughout the month of March. And so the European AI Office will become this kind of central enforcement or central brain at the union level for enforcement. But then every single member state will have to have two different bodies that will act as regulator for these acts. One that will have more responsibility for the post-market surveillance, and one that will have more responsibility on the ongoing compliance. Think about Data Protection Authority for that matter. But every member states will have two different authorities. There will be then this European AI Office at the union level, and also another body responsible for the post-market surveillance activity. So it's going to be complex, and it's going to take time for this whole network to be able to operate. So I think we are really looking for the whole kind of set here, maybe 2 years and a half from now to have it all up and running.
That's interesting. I have a two-part question, which is, we liken this a lot to the GDPR. In the GDPR, you had very specific fines laid out, like 2% of revenue, and that gave it some teeth. Is there anything that specific in the AI Act?
The fines are going to grow consistently with the type of violation, but there are fines up to 7% of global turnover. So it can be significantly high in terms of fines.
Well, that should be the headline. I would lead with that if I were putting out a press release from the EU. Wow, 7%. And then you've mentioned a couple of times that there's a risk-based approach. So there's prohibited use cases and there's high-risk use cases. And I was also wondering, like the GDPR lays out very specific things that are the rights of the data subject. Like, are they very specific about what those prohibited use cases are?
They tried, let's say that. So on the prohibited use cases, then you have a list of use cases. So social scoring, for example, that is going to be prohibited. Categorization of individual on the basis of some sensitive aspects like political views, for example, sexual orientation. Those kind of things are prohibited together with others, and we have a list of those. Then we go into the space of the high-risk use cases. And for that, we have a starting point. So this is where an AI system is used as a safety component or is a product in a domain covered in existing product safety legislation. And all products are also required within the legislation already a conformity assessment. So there are very specific cases. Think about lifts, for example, of medical devices or other things of that nature. So very specific. There are other type of high risk use cases. Again, they refer to 8 specific domains. So employment and management of worker, for example, or a technology that is used to determine whether an individual has the right to access public or private services. It may be, the access to a loan, for example. So if AI is used as part of that kind of technology or is making that determination, that specific use case will be high risk. So there is a list of 8 sorts of domains. And there are, for example, technology that is used to profile individuals, largely is considered to be high risk as well use cases. So those are the starting points. Of course, there will be a way to evolve these. And also many companies are asking, well, what is beyond that? What is beyond the list? How do I make a determination that actually my system, even if not squarely following in this list, might still be considered a high risk use case? And this is a question that we hope the regulator will clarify, the EU will clarify over time. There are then some limited risk use cases where the transparency obligation will actually leave. Think about anything that creates synthetic content, for example, that has to be marked as such, or anything that is created to interface with an individual, so chatbots. Those are, for example, limited risk use cases, and they will have this transparency obligation. And then there is the whole aspect of the general purpose AI, also has a component of a risk-based approach, which is generative or general purpose AI with systemic risk and without systemic risk. And I can tell you that determination is very uncertain. They said that actually one of the things that the European AI Office will do will be creating a tool that will help organizations understand whether their general purpose AI system is with systemic risk or without systemic risk. But the way that determination is made today, it is very, very shaky, very uncertain.
Prohibitive means no, absolutely not, you can't do it? Or does it mean if you do it, you have to proceed with caution? Well, because I'm thinking about some scenarios, like you mentioned, employment and anywhere where there could be bias against an individual on certain characteristics, et cetera. But the interesting thing is in some scenarios, we've found like AI is actually more objective and fair than a human being. I mean, I think the assumption is always that the human being, if you have a human in the loop, it can prevent some of the biases. But I'll give an example. Like here in the US, for example, they found that AI systems were actually, in sentencing of individuals who've committed crimes, that AI systems were far more fair and objective in sentencing than actual judges themselves. And judges tended to be lenient in the morning, and then as the day wore on and they got tired and cranky, they would be much more harsher on the individual. And it led to a lot of unfairness in it. So I don't know, do you inadvertently kind of rule out places where AI actually would be better than human judgment?
Okay, there are a couple of things here. So the unacceptable use cases, the idea is these are unacceptable, but what you have described, it feels much more on the high risk use cases rather the unacceptable use cases. These are unacceptable use cases where the AI is doing, again, categorization of individuals as this person is likely to commit crime. Those kind of things that are just based on some characteristic of an individual, and you come to those sorts of conclusions, those are prohibited. I mean, there is not the nuance of helping making a decision. These are systems that will fully make those kind of determinations, and those are prohibited. There is not an adjustment mechanism. These are prohibited in the EU. There are the high fines associated with that. Then there are the ways in which, for example, there is a whole component around the use of AI in criminal justice. There are situations where actually the AI system might be used just not to make a full decision, but to support a judge, for example, in making a decision. That will the provider of that solution, the user of that solution will have still to comply with some requirements, but they have good ground to say this is only an ancillary function, for example, that is supporting our decision making, therefore will only follow certain requirements in that sense. And then even when you have system, they might be also making more of a less ancillary function, but they are acting like, fully making those sorts of decisions, they can still operate in the EU as long as the provider and the user of that system complies with the requirements of the act. So those are not prohibited necessarily, but it requires that the provider of the user actually comply with the requirements.
Back to prohibitive use cases, are there any carve-outs for national security the way that there is in GDPR? I'm thinking right now the Paris Olympics this summer. I know specifically they're going to be using biometrics in their video surveillance. So for government, for national security agencies, is there a carve-out when it comes to AI?
On that specific use case, yes. So the real-time remote biometric identification can be used by law enforcement in some very specific cases. Now, that was also one of the things that different member states couldn't agree on completely. And in fact, their regulation now is also giving the opportunity to different member states to decide which specific procedures will have to be followed by law enforcement if they want to use some of these technologies. So the details really will be dealt with at the national level for when law enforcement can actually use these real-time remote biometric identification system. Of course, is all security, safety based. The idea that if you don't use the system, a major accident may happen, and so it's necessary to prevent something major from happening, and so forth. But a lot of the details will be dealt with at the national level.
So let's talk about applicability for a second. Everybody has experience with the GDPR, which of course applies to firms doing business in the EU, not just firms headquartered here. Is the AI Act similar in terms of its applicability?
It's possibly even broader. So it's for everybody. There is every company, every provider that want to sell their systems in the EU. Is for anybody using the system within the EU. So provider, users, whatever is the their role into that AI supply chain. But it's also for companies that actually are not physically using the technology in Europe, but actually will use the outcome, the insights of the technology on the European market. Interestingly, if you're using data of Europeans within your AI systems, and even if that is not going to go back in terms of insights into the European market, you still will have to comply with the rules. So it's really, really broad. It's really broad in scope.
Wow. I hadn't quite realized that it was even broader than the GDPR. So that calls to mind another question, which is, so looking back to sort of 2018, we can clearly see that the GDPR influenced privacy legislation all over the world. Do we expect the AI Act to be similar in the sense of other jurisdictions will adopt legislation that looks a lot like it, or do we expect very different regimes in other places? What do you think?
It's a difficult question in many ways. What I would say is that definitely there are aspects of the AI Act that I think will be used as a baseline in other region. And I think that is fair to expect. Some of the requirements on transparency, for example, maybe some of the requirements on the list of prohibited use cases might be another place where many countries might start looking into that. I think also the idea of the risk-based approach is a valuable approach. I think that might also be copied somewhere else. The idea that you don't regulate the technology as such. And I'm really referring to the classic AI systems, not the general purpose AI. But when they have, decided, let's have the prohibited use cases, high-risk use cases, limited risk, and then minimal risk, and let's make sure the requirements apply to these different levels, and they are different for different level of risk. I think this is very valuable, and I think this kind of framework it will be used elsewhere. Now, there are some of the specific requirements that definitely are probably not the one that other regions are going to look into. For example, the way this legislation is looking at the general purpose AI systems, I think that is so shaky in many ways. I do not think that represents the best example for other regions. So it will be mixed. There will be aspects of it, definitely, yes. I think other regions, other countries will look into replicating, and there are parts of the act that I do not think other region will ever want to replicate.
And so I was thinking about what you said, and one of the things that you said was that the way that it deals with general purpose AI is on shakier ground. So I wonder if you could elaborate on that. What do you think is sort of lacking in the AI Act, or sort of that other regions won't want to adopt in that area?
Yeah, I mean, these parts of the regulation, first of all, was added very last moment. If it was 2019 when I think the European Union sat down to think about AI, how to regulate AI, and there are a number of studies they have produced before coming to the Act. The legislation around the general purpose AI was added maybe less than a year ago. I mean, it was really, really urgent, and you can tell there wasn't the same kind of process that they follow for AI. At least that's my opinion. Think about the way they are starting to assess the different risks. So to determine whether a system has a generative AI system, general purpose AI system has systemic risk, it depends on the computing power that was needed to train the model. I mean, that can change any day. I mean, there is not a stable principle to make those risk assessments. And then also the EU said, well, if we decide that a general purpose AI system is with systemic risk, that will be it. And again, it leaves you thinking how these assessments are gonna be made. I mean, it creates a lot of uncertainty because as a company, I might be using a certain system and I might be thinking, okay, this is not with systemic risk, so there are requirements that are not important to me. And then you may say, hey, wait, we have decided that now your system has systemic risks. So you have to go and add activities to your compliance roadmap because now the EU has decided that that system has systemic risk. So the starting point is really the assessment is very unclear. I don't think will stand the test of time, as they say.
It's interesting. The world tends to lean on the EU to lead on ethical dilemmas like this one. But is there any concern that the legislation will have a dampening impact on AI innovation in Europe?
Yes, there are concerns of that nature. Obviously, there are a number of things that are problematic that way. When I read through the Act, for example, there is a requirement for provider of this technology to foresee risks and say, well, my system will learn, and these are the risks that may occur in the process of learning. But to make those sorts of risk assessment and then to provide instructions to people about what to do when that happens, you already have to cap somehow that learning capability of that system that goes to market. You cannot leave it just free to learn and evolve in the way it would depending on the data it's given. So even that simple example shows that necessarily to make sure the compliance structures are placed around these systems, you have to create some limitations in the way the systems themselves work. And these are examples of the way there might be limitation to innovation. There is also the discussion around copyright, for example, the fact that their legislation is not only asking to some of the provider of, for example, the general purpose AI system to, of course, comply with all the regulation around copyright, to produce their own kind of policy for intellectual property protection, but it is a process where you're trying to say others that have that have intellectual property or material that is used within the system for training purposes will have to be recognized somehow. Is a very good principle, is a very fair principle, but clearly introduces a step in that process that might be problematic in the moment you need to recognize, okay, where is this data coming from? Who has ownership of this material that I'm using? And how do I come to an agreement where I compensate or ask for permission to these people? Again, it's a fair, in my opinion, is a very fair measure to have, is a fair step, but clearly it's complicating the process of training of a model that we have seen so far. So there are concerns. I think some of it is necessary. Some of it is going to be very clunky.
So it's interesting. The clock's already ticking. I mean, I think you said 6 months to comply with anything that's prohibited. And then 12 months after that, anything that's high risk. And then 24 months from now, it's in full effect. What do you do now? Like, what is the first step that organizations need to take?
Um, Generally, I think this is a good time to start doing that inventory of your AI system and generative AI system, general purpose AI system, again, adopting the language. Create a registry of those systems, and then fundamentally run risk assessment to determine which category do these systems actually will fall. Is that a high risk? Is that a prohibited use case? And then really focus your effort on those generative AI systems, because in that 12 months time frame, compliance for this system is expected. And again, as we were talking, we have not many tools to really show that we are compliant when it comes to what do we, when you say I need to have documentation around training and testing. I need documentation in an instruction to the user, for example. We don't have, again, templates and tools for that. And I think organizations will have to figure out themselves what that is.
So I have a follow the money question, which is anytime you have a sort of landmark piece of legislation or regulation like this, you get a sort of bonanza of services being offered by all kinds of consultants and experts and lawyers and so on and so forth. And so I'm curious as to whether complying with the AI Act is going to provide as large a windfall to those kinds of service providers as for just to help companies figure out what to do and when to do it and how to do it and so on, as we saw with things like the GDPR, like Sarbanes-Oxley long ago in the US, etc. What do you think?
I'm seeing a very different approach in the market, and I think that GDPR also has changed or has contributed to change that. When we started to work around GDPR, the default was let's look at the services offering, the consulting the consulting companies to really understand what to do with it. The idea that actually software was created specifically to solve those compliance challenges was a realization that came after. And so companies that needed to comply with GDPR went services, and then slowly they started to move into software. While today the conversation with clients very often they are starting with, is there software that is going to help me manage compliance requirements with these regulations? So the market learned that actually there is purpose-built software that can really help them get started. And in fact, I'm seeing offering emerging from software vendors that really look with the registry of the system, the first risk assessment and the classification of the system. So there is an opportunity to get started with software. There are, for example, a number of the providers of ML technology that also are developing their own support for compliance. So there is more from a software technology perspective that there was in 2018 when we did the GDPR. But there is no question, of course, the legal firms and the consulting firms, they are all out there to provide their services to clients. And I think the clients this time, with probably more specific demands and kind of very more specific question will go to those services, but it's not going to be like, okay, come tell me do I have to do, and it's not exactly like that this time.
So I'm going to ask you to make a prediction. So when I think back to the GDPR and when it went into enforce, as somebody who's considers themselves a privacy advocate, I was rooting for the data protection authorities to come out swinging with really big fines. If I remember correctly, I think they were a little cautious. I think it took several years after enforcement before we started seeing fines really roll in. And I think it's only even been in the last few years we've really started to see large fines. And then in some cases, they'll end up rolling back the initial large fine. I mean, what's your prediction? Do they come out swinging, or are they going to be really cautious? Because as you said, there's a lot of guidance that still needs to be issued. There's tools and templates that needs to be created. So are they going to slow roll enforcement?
I think it's we have to wait for this enforcement network to appear and to be working. So I think that certainly without those bodies that are there to enforce the rules, it's going to be a little difficult to see the fines first. So I think we have probably a year, realistically, to start to see something happening. I mentioned at the beginning the European AI Office will have some responsibility for the prohibited use cases. So in the next 6 months, potentially they can start operating. But I think it's reasonable to believe that it will take at least a year before we see something happening. And I do think that that there is an intention to make sure that everybody understands that this is something that this is serious, that they are serious, that the EU is very serious with the enforcement of these rules. And it's possible that we are going to see some large fines coming. I do expect we'll follow the GDPR route, in which some violations are fined very, very little. And maybe there are a handful of cases that actually will make the headlines. So companies shouldn't be, because you don't see the big headline, it doesn't mean that they are not enforcing the rules exactly as it happens with privacy. There is enforcement going on, but it doesn't get to the headlines. And I think in that sense, we're going to see something similar, maybe activity that will pick up, but will not make the headlines. And then maybe a handful of cases that will really make those headlines. But we have time to think about this prediction. Again, I think we have a year to think about it.
Excellent. Well, Enza, thanks so very much for being our guide to what to expect from the EU AI Act over the next 24 months and beyond. We really appreciate it.
It was my pleasure. Thank you for having me.
If you like what you heard today, subscribe to Forrester's What It Means podcast on Apple Podcasts, Spotify, or your favorite podcast player. To continue the conversation, follow Forrester on LinkedIn or drop us a note at podcast@forrester.com. Thanks for listening.